Of good questions. Maybe we will be able to act like a Senate committee and send them to the administrator for written responses. And if so, we'll put them on the website. Moderating our next panel is my colleague, Catherine LaCroix, who teaches environmental law, land use, and federal courts. Previously, she had been a partner at Hogan and Hartston in D.C., and prior to that, clerked for then Judge Stephen Breyer on the U.S. Court of Appeals for the First Circuit. And I'm going to turn the podium over to Catherine, who will be moderating our next panel. Catherine?
Thank you, John. It's wonderful to participate in this inaugural program of our new Burke Environmental Law Center. I think this is a terrific way to start a new enterprise for Case Western Reserve University. We have a wonderful panel on our topic, Perspectives on EPA's Decision-Making and Regulatory Performance. Dr. Joe Aldy is a professor of the practice of public policy at the Harvard Kennedy School, a university fellow at Resources for the Future, a faculty research fellow at the National Bureau of Economic Research, and a senior advisor at the Center for Strategic and International Studies. His research focuses on climate change policy, energy policy, and regulatory policy. In 2009 to 2010, he served as Special Assistant to the President for Energy and Environment at the White House. He also previously served on the staff of the President's Council of Economic Advisors. Dr. Cary Coglianese is Professor of Law and Professor of Political Science and Director of the Penn Program on Regulation at the University of Pennsylvania. He specializes in the study of regulation and regulatory processes with a particular emphasis on the empirical evaluation of alternative regulatory strategies and the role of conflict and cooperation in business-government relations. His books include Achieving Regulatory Excellence and the one thing we all want to know, does regulation kill jobs? Dr. Dan Walters, who will be presenting with Cary Coglianese, was a regulation fellow in the Penn program on regulation at the University of Pennsylvania Law School prior to joining the faculty of Penn State Law. He brings an empirical approach to the study of public law and regulatory policy. Several of his works empirically test the effects of judge-made administrative law doctrine on agency behavior. Other empirical work focuses on the often overlooked domain of agencies' regulatory power of discretionary non-action and sheds light on how this aspect of administrative decision-making should be cabined or made more transparent. So these are fascinating and understudied aspects of regulatory policy law. And then Professor Emily Hammond is the Associate Dean for Academic Affairs and Professor of Law at George Washington University Law School, where she focuses on energy law, environmental law, and administrative law. Professor Hammond is a former environmental engineer with technical fluency in the cutting-edge issues at the intersection of law, science, and policy, and is co-author of one of the nation's leading energy law texts, Energy, Economics, and the Environment, and the environmental law text, Environmental Protection, Law, and Policy. So we have a distinguished panel here, and I look forward to first hearing from Cary and Dan.
So Joe's PowerPoint is up. Do you want to just go first? Or
it's going to be a fascinating presentation.
Talk about evaluating regulatory performance.
Do you want to go, or do you want to wait for this to...
You would like, that's okay.
Why don't you guys go? If we can get it up.
Can someone put up the other slides? That would be great. Not yet. Okay. There we go. Thank you.
Okay. Well, thanks again to Jonathan Adler and Case Western and the Case Western Law Review for hosting this. This is a great event, and really have learned a lot already. I guess it falls to me to follow the EPA administrator, so not something that is
You've
coveted
done before?
or done before. Yeah, exactly. We're going to be talking about Quartz and the EPA, and you might be wondering how that relates to decision-making and performance of the agency. But as I think the first panel suggested, it's hard to imagine what the agency's performance and decision-making would look like without court review. It's our task to sort of dive into that relationship between courts and the EPA in a little bit more depth. By any measure, EPA has a special relationship with courts. By pure numbers, EPA has consistently been featured in litigation at a higher rate than other agencies. And the graph you see on the left side of the screen is just the Harvard Ngram tracker. So this is mentions of the EPA relative to other agencies. And as you can see, EPA right off the bat gets wrapped up in courts at a higher rate than other agencies. And then also focusing on just key cases, you can see that EPA has been central to the development of doctrine in administrative law, the administrative law that applies to all agencies. Certainly the Massachusetts versus EPA case is a foundational case in the law of standing. Chevron versus NRDC, of course, lays out the most important standards for statutory interpretation and deference to agency interpretations of statutes. In the arbitrary and capricious domain, a number of cases in the 1970s laid out the hard look standard, and EPA was really primarily involved in a number of those important cases. You might add to that list Michigan versus EPA just a few years ago, holding agencies accountable for cost-benefit analysis, even when statutes aren't necessarily clear about whether they're requiring that kind of analysis. So the bottom line is that the relationship between EPA and the courts has been formative, not just for EPA, but for all agencies. And that doesn't seem likely to change anytime soon. And scholars have certainly noted this relationship and how important it is. There's really too much scholarly work out there to go into in any depth, but just make a few notes about some of these foundational works. Much of the early literature, particularly Melnick's study of the implementation of the Clean Air Act in 1983, showed quite a bit of dysfunction in the relationship between courts and the EPA. That narrative about the court's interference with EPA's efforts to roll out the Clean Air Act was pretty foundational to a general literature called the ossification literature, which suggested that court review was unduly hampering agencies' ability to move forward with rulemaking tasks that had been assigned to the agencies by Congress. Later waves in the literature, my co-author on this paper included in the early 90s, suggested that ossification thesis might have been a bit overstated, and I'm sure he'll talk a little bit more about that in his part of the presentation. Our goal in this paper is to try to stitch together some of this work, which really has focused on narrow snapshots of time and tried to characterize the relationship of the courts with EPA, and stitch these works together, bring in our own data to try to create more of a 50-year retrospective on the relationship of the courts and EPA. So with that, I'll go ahead and turn it over to Cary to talk more about what we plan to do.
Great. Thanks, Dan. And thank you to the Case Western Law School and Law Review. Congratulations on your new Environmental Law Center, and congratulations to Jonathan Adler, the new director, and we applaud the great work that's going on here at Case Western. In terms of the topic that our paper is focused on that Dan has introduced, this slide, I should say, also indicates, if you look carefully at the names of some of the folks contributing to this literature and the names of folks who are around the room, there are plenty of others in the room who can speak to these issues, and we look forward to conversation. What we're doing, just to give you an idea of our plans in this paper, and we have data collection already underway. First, we will try to synthesize this existing literature that Dan mentioned, but then we are collecting additional data and trying to bring up to date some of the research that I and others have assembled over the years, as Dan says, to try to create a more comprehensive temporal picture of the relationship between the EPA and the courts over the last 50 or so years, and then to provide some up-to-date analysis of questions about litigation rates, about who's actually suing the EPA, how the EPA fares in court. This figure gives you just an illustration of what a temporal portrait of the relationship between the courts and the EPA might begin to look like. It's simply charting over the last 5 decades the rate of and frequency of publication or issuance of court decisions in which EPA was a party. These are Court of Appeals decisions. Many of them will be involving EPA rulemakings, but at this first cut, this chart gives all cases in which EPA was a party in the Court of Appeals, so that can include all sorts of appeals of enforcement actions, of FOIA decisions, of employee discharge complaints, and so forth. But it is instructive that I think over this period of time, there's about an average of 53 published, released Court of Appeals decisions every year, enough to keep environmental lawyers very busy, and environmental law professors and environmental law students doing a lot of reading. The 2 other things that I think are important to see from this portrait. First of all, it probably isn't a 50-year retrospective, but technically a 49 or so year retrospective, because the first court decisions really didn't, involving the EPA, didn't come out until the agency was at least a year old. But second, and I think more instructive, is the pie chart here. The blue indicates, out of all of those cases over the years, the ones that came out of the DC Circuit. And you can see it's roughly a 50-50 split, really, between the DC Circuit and all other circuits, indicating the dominance of the DC Circuit here in the relationship between EPA and the courts. And if one looks actually since 1999, or actually about the year 2000, there's been a real dramatic shift. What occurred before 2000 was that about 2/3 of the Court of Appeals decisions with EPA as a party came from other circuits, and 1/3 came from the DC Circuit. Since 2000, actually, that has reversed itself, and about 2/3 come just from the DC Circuit, 1/3 from all of the other circuits. So that is, I think, important for our purposes because we will be sampling a lot and looking a lot more closely at the DC Circuit than in other circuits in this study. And in particular, that's an important place to look because in the Clean Air Act and in the Resource Conservation and Recovery Act, there's mandatory venue in the DC Circuit. So when we're looking at the rate, as we will be doing, the rate at which EPA rules are challenged in court, it's really helpful to have that mandatory venue to know that if any EPA rule under those statutes will be challenged at all, it would be appearing in the DC Circuit. And that is one of really the issues that we're looking at here, is what is really the threat of judicial review. Some of the early views on this were that, and I think you actually heard EPA Administrator here, Wheeler, say that everything will get challenged in court. Probably everything that he's spending a lot of time on will get challenged in court. But it turns out that there's actually a lot of EPA rules that never get challenged. You heard in the first opening panel today, a lot about Bill Ruckelshaus, the first EPA administrator. Well, when he came back for his second tour of duty at EPA, he reported that he was struck with how much there were lawsuits coming across his desk involving EPA rules. He didn't remember so many of those in the early years. Now, they were actually early years, of course, but he asked his general counsel at that time, tell me, how often are EPA rules challenged in court? And the person in the general counsel's office who gave him the answer, who specifically gave the answer just sort of on an off-the-cuff basis, he said about 80% of EPA rules end up getting challenged in court. And then Ruckelshaus gave a series of speeches around the country in which he used that statistic. It turns out that as much as that statistic had taken on a life of its own, when I was looking into this more closely in the mid-90s, that the statistic actually is about reverse or opposite. About 20% of EPA rules overall end up getting challenged in court. And even if you look under some of at the major rules under RCRA and the Clean Air Act, 35% or so of those are challenged. So a lot lower litigation rate than has often been assumed. And then some work that Bill Jordan has done has shown that when EPA actually loses in court, often the remedy is a remand, and Jordan finds that about 80% of the time EPA is able to return to the issues and fix them and accomplish its goals. So the idea of judicial review as a threat, at least based upon the literature that we have today, suggests that it's not as dominant across the board as some had previously thought, and certainly Ruckelshaus had claimed in the 80s. But we'll take a look, and one of the things we're going to be looking at is how that plays out more recently and over time. When you get an EPA rule in court, how does it fare for the agency? Well, we know that business groups are actually some of the most frequent participants, both in rulemakings and in legal challenges to EPA rules. Maybe that's changed, actually. We'll have to see with more recent data with the role of the states in more recent years. But business groups in the existing literature are found to be frequent litigants. But does that mean that then the courts are really the place where there's an anti-regulatory or a business-oriented approach? I think the findings in the research literature, Wendy Wagner's work is included among them, have shown that the picture is much more complicated, that when cases actually do get decided by the courts, EPA wins with some regularity, and in some cases you actually see the courts prodding the agency to engage in more regulation. Back when I was looking at this in the mid-90s, EPA had a win rate of about 51% across the board of the DC Circuit. That means there was, the courts gave the rule a total clean bill of health. Even when the EPA loses, it's not losing necessarily on every issue, and as Jordan's work showed, even when it loses on some issues, it comes back again. So I'll turn it over now to Dan to wrap up where we're going to take this.
So you heard Cary talk about how when the agency loses, it oftentimes comes back. But also, as he suggested, the EPA oftentimes does win. So the literature seems to suggest that the win rate is somewhere between 30% and 50% over a pretty broad historical period, which is pretty good. But the elephant in the room is, of course, the Trump administration's win rate, which, if you follow the Institute for Policy Integrity at New York University Law School's count of court review of deregulatory actions, it's about 7%. And I haven't done the statistics, but that seems pretty statistically significant. So the question is whether that is exceptional. And I will say that there is a lot that we don't know about how exceptional the Trump administration's record in court is. Our initial data would suggest that certainly the Trump administration has not been sued more often than it has been or the EPA has been sued in other administrations. So there's a lot of questions still about just how exceptional this period has been. But it's enough to sort of raise the question, which we want to explore in the paper, how EPA's win rates and all of the other things we've been talking about change over administrations and change as the composition of the courts changes. And more longitudinal data of the kind that we're going to collect and are collecting for this project could shed pretty substantial light on that and help us explain just how exceptional or not this administration's record has been. So just like to close by saying something about the source of this variation that we hope to explore. As the late Judge Patricia Wald suggests here on the quote on the board, much of the variation probably comes from a deep tension in administrative law between deference and scrutiny. And fluidity is probably going to persist into the future as courts and politics change. And we can learn more about all of this, I think, by the kind of retrospective longitudinal study that we are hoping to conduct and to see into the future, perhaps, about how this relationship between the EPA and the courts might change going forward as the Supreme Court changes and as politics change.
And we look forward to your thoughts or questions and ideas about hypotheses or questions that we should be thinking about as we gather all of this data that we are in the process of gathering. Thank you.
Okay. Thank you, Cary and Dan. Now we would like Professor Aldy's slides back up, if we could. This is fascinating because just when you're talking about perception versus reality, in the mid-90s, when you did your initial survey, the conventional wisdom in private practice was the government always wins. Mm-hmm. And your statistics show, in fact, 51% of the time, which is not always by any stretch. So, all right, our next speaker, Professor Joseph Aldy.
Great, thank you. It's a real pleasure to be here. Thanks to Jonathan for the opportunity to participate in the workshop, and to everybody here at Case Western Reserve School of Law for their efforts in pulling this together. Since I'm an economist, I should also right now thank whoever is the 2L who'll be assigned to my footnotes, who will get probably a disproportionate burden compared to the other footnote editors for this issue. Let me note at the beginning, too, that what I'll be presenting draws from a number of projects that I've been working on in recent years. One on the durability and adaptability of the Clean Air Act, a project that Ann Carlson led with Dallas Bertrand, Resources for the Future, where I got to spend some time understanding fuels regulations, and you'll see a little bit of that in my presentation. An ongoing project composed of economists looking at the performance of environmental regulations and using tools of retrospective analysis led by some colleagues at Resources for the Future, as well as a project that I've been undertaking on how to evaluate energy and environmental regulations. I also disclose and note my appreciation for funding from the Sloan Foundation and the Smith-Richardson Foundations for those projects. Actually, I need this keyboard. Thank you. So let me note briefly where I'll be going with the presentation here today. First, some comments and really some questions to sort of motivate why it's important to undertake retrospective or ex post analysis of regulations and to do so in a rigorous and credible manner. Then I will provide a sort of an illustration. I'll look at some of the empirical literature's focus on the performance of cap and trade regulations under the Clean Air Act. And this will do sort of double duty. First, to say, look at what we've learned about the performance and look how well these cap and trade programs have performed. What are the impacts on cost? What are the impacts on the environment? What are some of the unintended consequences that we've learned as a way to sort of understand just how has the Clean Air Act performed in its past, but also to start to illustrate the kinds of tools that are used in empirical evaluation that can inform what I'll discuss in the final part of my presentation, which is how we want to design a system and institutionalize a way of undertaking retrospective analysis of regulations. As a note, I also say it's great to be on a panel with Cary on this. This is something that Cary's been given a lot of thought to over the past decade or so. So some of what we'll see at the end, I think Cary will nod his head and say yes, and then some of it will say like, okay, well, I'm disagreeing with Joe again, but he's already heard me say that before. So let's turn now to a few questions to sort of motivate why we think there's value in undertaking ex post analysis of regulations. First, there's a kind of like, I think, first order question you would have if you're, say, a member of Congress and you've given a regulatory agency authority to implement a set of goals that Congress has established. You'd like to know whether or not the agency is actually delivering on those goals. You'd like to know that if you have said you need to go do X, Y, and Z to achieve certain things that we think are to the benefit of our society, that we're actually making progress on that. So there's this sort of first order question of, is the regulator doing the job it's been tasked to do? And some of this, we've seen a number of these figures earlier today showing the dramatic improvements in air quality over time, and it truly is impressive how much we've seen that improvement. But there is this question about how much of that is because of the Clean Air Act, and how much of that may be because of other factors, changing the composition of our economy, changing in technological innovation, some of which may be independent of environmental regulations. So there's value in really understanding what's really the driving force from our regulatory interventions in improving our environment and what may be caused by other factors. The second, to get to something that at least White Houses dating back to 1981 have been interested in, is, are we actually increasing social welfare? So whether we go back to the Reagan executive order that the benefits had to exceed the cost, a slightly softer version of the benefits having to justify the cost, that's an executive order 12866 from 1993, there's been this interest of saying, are we actually making society better off with our regulations? And so there's a lot of value in doing this in an ex post way. This approach, both these executive orders have really driven an intensive investment in the EPA in prospective analysis. And in fact, if you look across the entire federal regulatory program, it's hard to find a regulatory agency that undertakes, I think, a more scientifically rigorous and economically sophisticated analysis of its regulations ex ante than EPA. But we don't have the same kind of focus on doing this kind of work ex post. And sometimes things are different ex post than what we anticipated. And it's valuable to understand what the impacts of the regulations have been in practice with the learning from that experience. Third is the fact that EPA often either has to, because Congress says they have to, or an administrator will, by his or her discretion, want to undertake a review and an update of its regulatory authority. So whether it's, say, the National Ambient Air Quality Standards, which are supposed to be reviewed every 5 years and are reviewed something like every 5 years or more, depending on the pollutant and what's happening in the courts and things that are baffling to me at times, but then again, I'm trained as an economist. But the question is sort of, if we want to update these regulations, there's a lot of value in understanding how well they've been performing to date. And in fact, what we tend to see is, say, in the context of the National Ambient Air Quality Standards, there's the Clean Air Science Advisory Committee. They're trying to review, often when they provide their advice to the EPA administrator, they're sort of reviewing sort of the latest on the science, not so much of what's the quality, the performance of the regulation to date. And so there's ways in which I think we can sort of change how we think about this so that EPA is doing a better job as it's going through its sort of periodic review and updating of its regulations. We see this in other contexts as well throughout environmental law, where EPA has this periodic charge to review and update its regulations. And finally, it can be the question of sort of, well, what would we want to say if we're to say the agency responsible for implementing environmental law to Congress to say, here's some things you could, we'd like to do better. We know we can do better. We've learned from evaluating our regulations we can do better, but we really think we're constrained by our existing authorities, and we'd really like you to update and revise our authorities. One example of this that I'll touch on briefly in a few minutes will be the renewable fuel standard, where I think everybody pretty much agrees it's not working. The challenge may be politically how you navigate that in Congress and navigate some of the key stakeholders, but it's one where we know we're not really delivering on what was the initial objectives from more than a decade ago when the renewable fuel standard was passed into law. So let me talk a little bit now about the sort of the performance of cap-and-trade programs. This is not going to be comprehensive or exhaustive of cap-and-trade programs implemented under EPA's authorities. You'll see that I'm focusing pretty much exclusively on air quality pollutants in one way or another, and some of that gets to a point I'll make a little later in the presentation about the availability of data. Often will inform where academics go to do analysis, and I think it has implications for how we think about institutionalizing analysis in the future. But also try to glean some of the key insights about how the analysis was undertaken to think about that next step of how we plan to undertake these kinds of reviews if we were to institutionalize that within the agency. So first, we've already heard from the first panel this morning about the sulfur dioxide cap-and-trade program under Title IV of the 1990 Clean Air Act amendments. Clearly a success, whether you're thinking about it from the standpoint of, am I improving the environment? Am I reducing people's exposure to sulfur pollution and related particulates? Am I doing so in a really thoughtful, cost-effective manner? The recent empirical analysis has gone back to look at its performance has suggested that we're probably lowering costs at least 20% compared to a command and control performance standard, that we have probably done so in a way that may not fully be maximizing the benefits of the program, in part because of, and there was some discussion about this earlier today too, the differences in where the emissions are occurring matter a lot for public health. So the way the SO2 program was created and designed and implemented is that we're going to treat a ton of SO2 the same anywhere among any covered electricity generating unit across the country. And you realize, though, that if you're, say, reducing emissions just upwind of New York City, you're going to have much larger public health benefits if you're reducing emissions in South Dakota. And it's just because where those emissions occur relative to densely populated areas matter a lot for the public health benefits. So there's some economic research suggesting we could really increase social welfare, really increase the public health benefit if we thought about being a little bit more sophisticated and perhaps sort of establishing trading ratios across different parts of the country. There have been some thoughts about this. We see, as I'll talk in a couple of minutes, the program to use trading in Southern California and Reclaim has a kind of trading ratio. There's sort of two regions, but there's ways, especially as we start to leverage, I think, a better understanding of atmospheric chemistry, better data, exploit some of the new tools in analyzing big data, that this may be something in the future that we could do where we have a little bit more of a sophisticated representation of the benefits of trading as we implement those programs. Some of this literature notes there hasn't really been much evidence of job loss in the power sector. And the other thing that's kind of interesting is recognizing that while the railroads were really critical, and the deregulation of the railroads were really critical in enabling low sulfur coal from the west to come into the Midwest, that the deregulation then actually evolved into a kind of rail shipping duopoly, and there was some market power where they captured some of the value of the SO2 allowance program and how they set their rail rates for bringing this coal to the Midwest. We started in late 1990s to regulate through cap-and-trade programs, first through the Ozone Transport Commission, and then through the NOx budget program, NOx across sort of the eastern part of the United States. Tremendous improvements in reducing the emissions, reducing ozone concentrations, and improving public health. So estimates of probably about reducing 2,000 premature mortalities a year, also reducing how much money people are spending on drugs and healthcare because we're improving air quality. One thing that's interesting is that we found that the utilities that were under economic regulation tended to invest more in capital-intensive equipment, and those that were in competitive restructured markets tended to do less of that. And that may have an impact on the spatial distribution of the benefits as well. That we also see that there's some evidence of manufacturing job loss as a result of this program, especially for younger workers. So it wasn't that we were firing older workers so much as just when older workers retired, a lot of these manufacturing plants were not hiring new workers. In Southern California, they implemented the Reclaim program to address primarily NOx, but they also address SO2. And the empirical evidence of this suggests that the units that were covered by Reclaim reduced their NOx emissions faster than similar units in California just outside of the Reclaim cap-and-trade program. And one thing relevant to a lot of current debates about especially climate change policy, but about what we think the environmental justice concerns might be, and there are some papers quite critical of Reclaim on EJ grounds, and yet the empirical work shows that there were not any hotspots that emerged, meaning that no one saw their emissions increase. There's differential decreases in emissions, But by census tract by census tract, everybody saw reductions in emissions under this program. And then the loser. So those first three, they're fantastic. They were cost effective. They improved public health. Renewable fuel standard, not so much. The 2007 revision of the RFS called for a very ambitious goal to increase the amount of biofuels in our gasoline and diesel markets. Really aggressive, if you will, technology forcing standards for cellulosic and advanced biofuels, really low carbon biofuels. We have not delivered on those. So given the original statutory goals, we've never seen more than 1% of the statutory goal for cellulosic ethanol met by the market. So EPA's had to go through this process of trying to revise the goals, and typically they do so in a way that elicits subsequent lawsuits, and we typically are not finding out what the target cellulosic ethanol is for the gasoline market for a given year until after that year has ended. Doesn't really create the kind of certainty you want if you're trying to comply with a standard, or for that matter, if you're an entrepreneur trying to innovate and bring this product into the market. There have been other problems with how this program has performed, with some fraud that's occurred through the program. And there's even some evidence that because of imperfect competition, we're not really passing through the benefits of subsidizing biofuels to consumers. So we're not creating the incentive for someone to say, I want to go buy a flex fuel vehicle that could consume, say, a high ethanol-based fuel like E85. So let me close with a couple minutes now about institutionalizing retrospective analysis. So first, all these studies that are referenced in some of our work that I summarized in the last few slides, they're all employing rigorous quasi-experimental methods in economics. And they're really able to distinguish and discern what are the impacts of the regulation from other factors. So they are able to establish in a rigorous manner the counterfactual so that we can say this regulation had a causal impact on this outcome X or this outcome Y. Part of that is that they're exploiting both the geographic and the temporal variation in the implementation of these rules so that we have a kind of, if you will, treatment group and a control group by which to estimate what we think is the impact of the regulation. Now, this raises really important data needs. A lot of these are evaluations done in the utility sector because we're already collecting an incredible amount of data, not at EPA, although EPA data are certainly being used, but at the Department of Energy, at FERC, and at the Energy Information Administration that analysts and researchers have been able to exploit to really understand the impact of these regulations. But it says something that oftentimes when we implement a rule, we say we want to collect data by the regulated entities. But by the nature of any of these designs, if you're really trying to identify someone who's not regulated, or not regulated at the same time, or not regulated as stringently, you want to make sure you're collecting data on them. They're going to be your control group in your analysis. So there's a lot that we need to think about with risk of bringing up discussion of the Paperwork Reduction Act, which may cause us to go to sleep before lunch, but that it may have important implications for having the data necessary to conduct rigorous analysis. The net analysis also suggests that there's, in a number of these markets, we don't have perfect competition, and some of the assumptions that are used in our prospective analysis aren't borne out by the experience in the markets, and we need to think about that and account for that as well. I would also note that what I was giving you were sort of snapshots from individual papers, and it's not like there's no one in academia doing what EPA does with a prospective analysis. We're not doing the full comprehensive analysis of all the benefits and all the costs. We're finding something narrow that we think we can actually estimate rigorously, and we focus on that. So there needs to be a job to try to synthesize across these rules. When we think about conducting this ex post analysis, there are clearly going to be important resource needs. There's going to be some pushback from the bureaucracy. We can talk about this some a little bit later during the Q&A if you want. So we got to be sort of thoughtful and really constructive in how we think about using scarce resources in a productive manner. So we want to think about how we target our rules for ex post analysis. So one, where might there be sort of positive spillovers to other rules where what I learn about this rule can help me think and understand the implications for other regulations? We might think about doing it in the context where I know I'm going to be doing this again and again and again, such as in the NAAQS review of regulations. It may be that rules that have really big or really uncertain benefits and costs are ones where I could really learn a lot by having a rigorous ex post analysis. And it may be that I care about the implementation strategy. And if the implementation strategy for one pollutant in one context may have insights in another context, I really want to undertake and study that. So to sort of get some closing thoughts on how we might plan for ex post analysis is one, let's try to be creative with, to the extent feasible, the discretion we have in how we structure rules to enable the learning. So we actually think at the beginning when you're designing a rule, how do I want to evaluate it in the future? And are there ways I can actually design that rule to really ensure that I have the variation necessary to estimate the causal impacts? How do I think about my data collection up front so that I can conduct this ex post analysis And I want to be doing this at the regulatory development stage, and I probably want to be soliciting feedback at the proposal stage. And then I want to work this into the actual rule that gets finalized and promulgated so that people understand how we're going to evaluate this rule in the future. And then how we end up using, as my closing comments on how we're going to use this ex post analysis. One is that this can inform, for those regulatory contexts where we have to do periodic review and updating, an ex post analysis of one is really going to be the starting point for the ex ante analysis for the next regulation. So it serves as sort of an information foundation for that. It can highlight opportunities for Congress for where they can revise authorities so that we can be more effective and deliver more environmental benefit for our environmental laws. We can make the data and the analysis public and actually have third parties evaluate these data and extend on them and maybe come up with clever, creative ways for how the agency can use their tools in the future to improve the implementation of the regulations. We can also do something which I think is important given the public debate about environmental law and environmental policy in the country and say, here's what these environmental regulations do. They're actually, thoughtfully designed. They're actually improving public health. Or there might be like, you know what? Not all of them are great. Okay, we'll admit the RFS is not great. It's probably not the only one that's not great, but there's ways we can make it better. We're going to learn from this and hopefully continually improve the implementation of the regulatory program. So here's a lot of fine print you can't read, but there are a bunch of papers if you feel like you need some reading over the weekend. I'm also happy to make this available to you if you want to email me or make the whole deck available from the organizers. Thank you again for your attention. I look forward to our discussion.
Thank you for that. It is true that right now it seems as though the work you've been able to do amounts to looking where the light is better, and what you want to do is design rules to shed light for the future, which apparently right now we're not doing. So our last speaker is Professor Emily Hammond.
All right. Thank you, and I want to echo the thanks of everybody on this panel, the gratitude for being here, to Jonathan and to Patty, who I understand can hear somewhere outside where she's making everything run, and also to the Law Review for hosting this terrific event. I thought I would say something today on the general topic of how EPA incorporates public involvement in its decision-making to hopefully improve regulatory performance. But what I'm going to come around to is the role of civil disobedience and other forms of direct action in that decision-making. And I will invite you to conceptualize citizen science as a form of protest. Well, why civil disobedience? We have seen examples of it today, but notice it seems to be on the rise, at least many people think so. Just last week, there was a headline from Reuters, "Scientists endorse mass civil disobedience to force climate action." Where there were climate strikes nationwide just a few weeks ago. Our students are doing this, our neighbors are doing this. Perhaps many people in this room are engaged in these actions. We also know, of course, that civil disobedience and protest have been along much longer than EPA. I do think, though, that in terms of both administrative law, but particularly environmental law, the role of these kinds of activities in our legal system is under-theorized, at least in the legal literature, and it's certainly very under-operationalized. It's hard to know what to do with that if you're working in an agency. So these are some of the themes that I'm exploring. I have a very early book project in the works, so I'm certainly eager to hear what kind of feedback you might have. Ultimately, as I introduce some of these ideas today, I want to suggest that at the very least, civil disobedience and protest operate as part of our civil society framework. They do provide a check on agency or government behavior, and I think they can also be seen as a point of improved government decision-making. First, I'll start, though, with administrative law. I think we all agree that, and I think many of the people who've written in this room agree, that most agency decisions are never reviewed in court. On the other hand, the doctrine that comes from that judicial review, as we've heard, sets up some norms, norms like deliberation, participation, transparency, and reason-giving. If we agree that those are worthwhile and even legally mandated, we should ask where else can they be applied outside of the big agency actions that see judicial review. Some of my past work on EPA's behavior in those other realms is actually fairly positive. So for example, Dave Markell and I did a project a few years ago where we examined the response of EPA regional offices to petitions to revoke state authority. And although those petitions were almost never granted, we did document a lot of what we saw as fairly positive behavior by the EPA regional officials. They held meetings, they did investigations, they were very responsive to the concerns that were raised in those petitions, and ultimately we also identified quite a few measurable outcomes resulting from those petitions. So there is something to be said for what happens at the regional and local level in terms of incorporating public involvement and improving decision making. Well, what else happens at that local level? Direct action. Let me do some terminology first. Civil disobedience. Here is John Rawls, the legal philosopher's definition. It's a public, nonviolent, conscientious political act done contrary to the law with the purpose of bringing about change in the law or government policies. So let's take, for example, people who locked themselves to equipment at the Spruce No. 1 coal mining site. This is the Mingo-Logan mountaintop removal controversy. Ultimately, during this same period of time, EPA vetoed the operator's Section 404 permit for that mine, and the courts upheld EPA's authority to do that. Often in environmental law, what we see is the legal violation of something like trespass. This is in distinction from civil rights protests, where often you see the law that's violated is the law that is being protested. So Rosa Parks is a great example there. Notice that these acts are communicative. Okay, this is the public component of the definition. They are a form of speech. They're also necessarily nonviolent, because to do otherwise would undermine the communicative nature and the force that those acts carry. The other thing that I think is interesting, at least from the legal philosophy literature about civil disobedience, is there's a fundamental commitment to the legal system underlying these activities. First of all, the person who engages in one of these acts is going to be accepting the legal consequences of the action. So the professor, and I know this person, who serves probation and community service as part of a sentence for trespass for locking herself to equipment just last summer. She knew very well that she was going to get arrested, and many people are planning for that when they engage in these activities. This helps demonstrate the sincerity of the act and the politically conscientious nature of it. The nonviolence demonstrates a commitment to the rule of law in the sense of minimizing harm caused by the act. And notice that the ultimate purpose is to influence the system. So this is not anarchy, this is actually a commitment to the system and a hope to improve it. Many contemporary activists speak in terms of direct action, which is more of an umbrella term. So more generally, direct action is going to include both legal and illegal acts of protest, and both violent and nonviolent actions. So for example, the protesters outside of the law school today were engaging in direct action. I don't know of any laws that they were breaking, and they were certainly nonviolent and communicative and all of the rest. So the emphasis of my work, I just want to point out, is on nonviolent direct action, whether or not it's legal. Okay, so I'm taking violent action out of the picture here. So with these ideas and this theory, let's think about how to operationalize it a bit, or at least what we can take from this kind of behavior for regulatory decision making. First of all, it tends to signal process concerns. There are ways we can learn from these actions about flaws in the system. So beyond, I should say, the mere presence of opposition, which is usually fairly obvious with some of these major controversies. So for example, there are ongoing protests to the Mountain Valley Pipeline, which is being constructed through West Virginia and Virginia in the Appalachian Mountains. And a lot of the process concerns there center around the administrative law of Burke, how it's behaving in this regulatory process, the process for eminent domain proceedings, the idea that people's land could be cleared before they are even compensated through the conclusion of an eminent domain proceeding. We can also see these kinds of activities signaling a failure of statutory purposes. Here, consider protesters outside of a power plant that has an unlined coal ash basin. Before it ever breaks, they're calling attention to the fact that there may be a failing there. To the extent that these kind of issues and activities take place during periods of agency decision making, I do think it's appropriate for EPA officials, and this is particularly going to be at the regional or local level, to engage with those issues on the merits. They may or may not be engaging directly with the civil disobedience, although I'll explain why I think they actually are quite often in a minute. But certainly there can be some issue spotting here, as well as indicators that environmental justice concerns may also be at play. So this brings me to citizen science, and I mentioned this idea that some of the people that the agency is engaging with already are also engaging in protest. So citizen science, this is roughly defined as the involvement of the public in scientific research. A number of my colleagues have just recently published a paper about it, and they've noted a boom in it because of advances in technology, an increasingly sophisticated public, limited agency capacity and data gaps, and then a growing attention to community level and environmental justice. Notice those last two sound a lot like the motivational component of traditional direct action. Now, citizen science is not new to EPA, of course. Many of us are probably familiar with the waterkeeper groups and how they often work with EPA officials to develop quality assurance and quality control procedures to help do environmental monitoring for waterways. Thus far, those kinds of programs have had a good impact for community engagement and condition monitoring, but they've had limited to no impact for regulatory standard setting, regulatory decision making, and enforcement. I want to suggest that that could be changing because one of the things we're seeing is that citizen science is being used not just as engagement with an agency process, but also protest. Here's a great example. The Environmental Defense Fund is planning to launch a satellite in 2022 to monitor methane emissions from the oil and gas sector. This is true even while EPA is working to roll back some of the regulatory protections from those emissions. One of the things they note on their website is they want to turn data into action. So again, this activity here is bridging two different worlds. Coming back to the Mountain Valley Pipeline example, there is a resistance movement to this pipeline. It's all coordinated by the same group. Right? There is one umbrella public interest group that is coordinating both the people who are locking themselves to equipment and sitting in trees and a grassroots monitoring network that citizens are using to create geospatial data. You can get online and see over 700 documented potential violations of water quality standards. And then they're using that data both to press regulatory agencies to undertake more enforcement, but also to promote support for the civil disobedience who are working at the same time. So I think there's an important gap-filling nature of this work. I think it's important to recognize that this kind of activity is on the rise, and what to do with it. I do think that certainly for citizen science, one of the needs we have is a better ability to ensure data quality so that it can be used for more of these kinds of things that we'd like to see. I argue that agencies should be very responsive to it. They should be transparent if they find flaws in it and give reasoned analyses. But ultimately, what I want to suggest is this could become a pressure point for judicial review, provided the the data is of a sufficient quality that it's significant, let's say, at the rulemaking level, an agency ought to be responding to it. And so that's at least one way that I think some of these things that really are a form of protest can get incorporated back into agency decision making. I'd also welcome some other ideas about it. As I said, it's in the early stages, but those are my initial thoughts. Thanks.
Thank you.
For that provocative contribution to our otherwise staid narrative. And now we have some time for the members of the panel to address comments or questions to each other.
Maybe this is, I don't know if this is a question or a comment or both for Emily to help us think through. There's an aspect of Rawls that is celebrating civil disobedience, right? And there's an aspect, I think, in which we ought to celebrate perhaps certain forms of civil disobedience, at least in certain circumstances or on certain issues. But what I'm wondering about is how one should think about official disobedience. And that may be not the paper that you're writing, but I do think that you are trying to connect up the civil disobedience and citizen science with governmental decision making. I don't know what the motivations might be, but we're certainly seeing in the news and as of late, not only numerous instances of the President of the United States just telling flat falsehoods, maybe justifying it as the ends justifying the means, in the same way that certain forms of civil disobedience might do that. What we have, the President's trade advisor in the news lately is having made up a fictional person who he cites and quotes in some of his work, apparently.
That person's an expert, though.
That's right. You have the Council of Economic Advisors in this administration putting out a report on regulation, taking seriously a figure of $2 trillion in costs from regulation every year, which is not a number that I think serious economists would go to the bank on. You have Hatch Act violations that are at least I guess found by certain ethics advisors. We have concerns today about presidential direction of policy toward fulfilling personal, financial, or political needs. I mean, all of these things are forms of violations of norms, legal or otherwise. And it's, by the way, I mean, there may be a qualitative difference, certainly, in this administration. It's not the only administration that has had questions raised about certain legalities. And the EPA, here we're talking about the EPA, under the last administration was found by the Government Accountability Office to have engaged in, I guess, activities that were a violation of the Anti-Deficiency Act for various quote-unquote propaganda over its defense of the waters of the U.S. rule. But so, I mean, where does one draw the line between this valuable civic forms of protest that might skirt the law or skirt norms? Do we just say that once you are a public official, none of that holds, or do public officials sometimes legitimately have a justification for engaging in their own form of civil disobedience?
Okay, very provocative question. I think that the Rawls definition helps us draw part of the line. And in part, that's in the commitment to the rule of law. I'm not certain that at least some of the actions that we're seeing actually do show a commitment to the rule of law. They seem to be instead an assertion of being above the law or not bound by the law. So I think there's a distinction there. I think there's also a distinction in the definition that points to a communicative act designed to bring about change in a system that is fundamentally seen as flawed or unjust. This is not to say that many officials, like what you describe, wouldn't like to change the system, but they're not protesting so much as just blatantly violating in many cases. So I think that some lines can be drawn there. Jennifer New has written an article, I'm sure you've seen it, on efforts by agency staffers, for example, to engage in acts of protest. So she's kind of fleshed out some potential parameters there. But yeah, I really am trying to focus on sort of citizen grassroots resistance efforts and line that up with an issue that we have in administrative law generally, which is how can our agencies engage in good decision making and incorporate that public input part of the process effectively. So that is where I'm focusing, but thank you for your question.
If I may, moderator's prerogative here, as a non-economist asking an economist, when we're evaluating welfare improvements of regulation, which is a topic of great interest, how far from the direct target of the actual regulation do we go to seek our cost-benefit analysis? Are there parameters you could explain to the non-economists among us? And the reason I ask this is this topic has come up that the main benefit of the mercury rule for power plants arises from the reduction in air pollution generally that the mercury rule provides, as opposed to strictly the reduction in mercury.
So I would say that most economists would be of the view that you would want to look at, when you're evaluating a regulation, you try to figure out what's the world going to look like without the regulation, what's the world look like with the regulation, and look at the difference. And that difference is something where you want to think carefully about what might be benefits and cost that are not necessarily targeted or the intended target of the regulation. So it could be that if you're concerned about, say, the cost of a regulation of power plants, it's not just that you're going to look at the costs that are borne by the owners of the power plants, but you might be concerned about what the impact of, say, higher electricity prices would be for energy-intensive manufacturing plants. And it may be that if they're having to pay more for electricity, you want to account for that. So it's not the targeted or regulated entity, but it's going to be some of the costs because that's the change that's induced by the regulation. If I look at the impact on air pollution, I mean, some of this is by the fact that the regulation in the law may say I'm going to treat this pollutant differently than this one. This one's the one that's being regulated. But the engineer who works at the power plant, who has to install a scrubber technology, is finding out that, wait, this scrubber, by its very design, captures more than just the mercury that's being targeted by the regulation. And so at the end of the day, you say, what does the world look like because of this regulation that's different than if I didn't have it? And I want to understand those benefits. If people, if we lived in a world in which economists could create a market for everything, okay, which is not, no one's asking for that world, but let's play along for a moment. And you say, I want to have cleaner air. And I would go to the drugstore and I'd buy cleaner air. I'm not saying that I want like this little bit on ozone and that little bit of PM. I just want cleaner air. And I'm happy to pay for it. And so if we were to actually give people a world in which says, hey, here is better air pollution. I have this thing. You don't even, I'm going to call it the mercury and air toxic standard. You've already lost like 90% of Americans by the fourth word. You just say, I have something that's going to make cleaner air. They'd say, hey, I'll pay more for that. That's great. And if they're willing to pay for it from an economist standpoint, that's the benefits that we want to capture. So this kind of, it's an arbitrary distinction to say, well, that pollutant was targeted and that one wasn't. It's just, what's the difference in the air? And are people better off because of the differences in the air quality, because I implemented the rule versus a counterfactual if I did not?
Okay, thank you.
I think there's also been a bit of an asymmetry politically in how benefits and costs have been treated in this particular dimension here. where co-costs, I think, folks in the business community have been delighted to sort of try to roll in, and however far extended they might be. You mentioned the book that Joe contributed to called "Does Regulation Kill Jobs?" and Brian contributed to that as well. There's a lot of interest coming out of the Great Recession in trying to add up all the possible costs of regulation, no matter how far remote and how uncertain they might be in terms of employment, welfare effects of employment, and so forth. And now we have some of those same folks who wanted to kind of add up and tally all of those, what I would call co-costs, now saying, well, but we shouldn't have these co-benefits included. I think the consistent approach that you've just outlined is the ideal approach to take.
And I think, in fact, in the past, we took co-benefits into account in the lead phase down. It turns out there were additional health benefits in adults way beyond the health benefits in children that were only realized after the lead phase down. I think this is time now for questions from the audience. Yes, here.
Dr. Aldy, this is a question for you, and it's kind of related to the scrubber technology that you referenced from some of these power plants. From my understanding, there's some difficulty in accurately estimating pollutant-specific damages, and I was wondering if that's kind of on your radar for your research, and maybe there's a way to address that to more accurately inform policy moving forward.
Yeah, so there's, the science here is we're really trying to draw from a number of disciplines to do this well, where we have to bring in the atmospheric chemistry, the epidemiology, the economics. Sometimes as economists, we can sort of cut out the middleman, with apologies to the epidemiologist. So, for example, when I talked about the NOx budget program, they found that there was this large reduction in NOx emissions. They saw a reduction in ozone concentrations. They saw some mixed evidence of reductions in fine PM. But one of the endpoints they look at is, are people spending less on pharmaceuticals and on healthcare? And they actually leveraged an incredibly rich business proprietary data set to do this. So they basically had like all the insurance claims for a fairly large population across the country. That they were able to look at and see how that varied with the implementation of this policy. We don't really know why people were consuming less pharmaceutical drugs, if it was because of the reduction in ozone concentrations, was it because of some of the fine particulates. We know that in aggregate there is this change in air quality, and we can see as a result of that policy. So in some sense, we're not saying I can say definitively what is the air pollutant reduction that caused this benefit, but I can say with a high degree of confidence that the NOx budget program causes significant reduction in expenditures on pharmaceuticals, and that I can see that as well on their mortality estimates. They use very high frequency refined data on mortality to estimate the change, especially among the elderly population, the change in premature mortality as a result of that regulation. So sometimes what we're doing is we want to go through this process where we say, here's the change in air quality, here's the change, and by pollutant, I have a dose response function for each pollutant. I say what kind of change that has to some outcome I care about, and then I'm going to bring in the economists and try to monetize that outcome. And sometimes we sort of say, skip some of that and just say, I have a regulation. I have a credible empirical strategy to estimate what I think are the causal impacts of the regulation, and I'm not going to really distinguish among the pollutants. And I think there is some effort to try to leverage better data. More and more economists are actually using atmospheric measurements of air pollution as opposed to EPA monitoring. There's even some evidence now that the people who are very familiar with this are probably not surprised by it. EPA monitors are not randomly located in the country. They are oftentimes, if they have to have new monitors in an area that may have high pollution levels, they may be suspiciously upwind of like the big factories in your town, as opposed to downwind. So there's a sense in which like even the data that we use to try to measure this aren't great. So we want to try to tap other data sources to better understand what people's exposure are to these pollutants.
Thank you. Professor Enton had a question.
Sorry about that. I want to pick up on on some data that Professor Coglianese and Professor Walters picked up on, and also maybe pick up on something that Professor Hammond mentioned. It seems that the conventional wisdom of how often the EPA gets sued is exaggerated, and the conventional wisdom on how often the EPA wins is also exaggerated. How much do we know about the extent to which these misconceptions influence the way the EPA operates, and maybe the way litigants or potential litigants think about whether to sue?
Well, I think I would first acknowledge that there's folks in the audience who've spent time in the EPA General Counsel's office and working on rulemakings, and I want to recognize them to contribute on this as well. I do think that there is a shadow effect that litigation has, even when a rule does not get challenged. In fact, one of the reasons why EPA may well have such a low litigation rate and a relatively high win rate is that they are adapting to the threat of judicial review and building the record. And I think one of the reasons that Joe could sit here and say, and I would agree with him, that EPA has one of the best economic shops in regulatory agencies is probably more to do with judicial review even than OIRA review, arguably, at least. I mean, that's speculative on my part, but certainly that has a lot to do with it, that shadow of judicial review.
Just to echo what Cary was saying, there have been a lot of studies of how agencies respond to comments and notice and comment. And overall, there's a lot of evidence that EPA and other agencies are very responsive to the commenters, perhaps more than they need to be to head off judicial review, essentially, right? So that might be an explanation for why the rates are lower. They're accommodating the preferences of the parties and the stakeholders who are involved in this process. I think somebody once called notice and comment a negotiation, right? And that is exactly what it is in form.
Professor Carlson, did you have a question?
Thanks. Great panel. Emily, I have a comment for you and then a question. The comment is, I think there actually are instances of citizen science, depending on how you define citizen science, actually changing regulations. So one example is the fence line monitoring that EPA is now going to do of oil refineries, which I think is the direct result of an EJ community in Louisiana getting pretty good science showing that emissions are higher than what was previously reported. And there's a similar law now in California that is the same, comes out of the same kind of monitoring. So I just think there's some great examples for you that are actually have had even better results than what you suggest. Here's the question I have. So I had a student write a paper on the number of climate activists who engage in civil disobedience and then try to raise a defense of legal necessity. And the idea of legal necessity is I had to do it because the conditions are so dire, and therefore you should let me off the hook. And so I'm curious, when you say that civil disobedient activists who engage in civil disobedience accept the law, whether that's really true. They don't really necessarily always want to accept the punishment, and how you think about that and what that might mean for, just your thoughts about civil disobedience more generally.
I guess I would distinguish between trying to use your best legal case from not being committed to the legal system, right? So even somebody who is in a trial as a criminal defendant, they're using a doctrine or defense that I think we all know has very little chance of success, but they're using it again within the structure of that system. So
they're not accepting the punishment.
So
the argument is I shouldn't be punished. So I just think maybe you want to play with it because it's an interesting kind of way in which you're both engaging in civil disobedience, saying I'm doing this within the system, and then saying, but wait a minute, I don't actually want to accept the punishment that I know is due me because the morality of what I'm doing is
I think I worry about saying that. I need to think through this, but about arguing that any criminal defendant who puts on their best defense is not accepting their punishment. I think those are two different things. And I think I would defer to people who do criminal law, which I don't, on those distinctions. But I think there is one. Saying there is a legally valid reason why I should not be found guilty is different from saying I disrespect the system and I won't accept a punishment if it is actually imposed on me.
Okay, another question for Professor Hammond is, I thought that was really fascinating, your talk, and whether you think there are lessons in thinking about how civil disobedience combined with citizen science can influence agencies from the engagement of ACT UP with the FDA during the AIDS crisis around clinical trials and licensing of AZT, because that seems like a really signal case of exactly the sorts of things you're talking about.
Thanks, I'll take a look.
Yes. Professor Elliott. Oh, sorry.
Thank you. Great panel. Very, very interesting. On the co-benefits issue, I'm inclined to agree with Cary and Joe that we ought to consider all costs and all benefits. But I would just point out that sometimes that's not what the Congress has done. So I think we have to make a distinction between the legal justification and the economic justification. So for example, with regard to the mercury and air toxics rule, it's promulgated not under a general section of the statute that says reduce pollution and consider costs and benefits, but under a section of the statute that says look at the harms or the potential harms from toxics, which are defined, do not include particulates, and they specifically exclude under Section 112 consideration of costs and benefits. So I think this has been a very clarifying conversation between about sometimes the difference between a legal analysis and an economic analysis. With regard to, say, the acid rain program, I think it's perfectly legitimate for you to look at the health benefits, even though when the program was enacted, it was specifically enacted as an ecological program, and we acknowledged that there would be health benefits, but we didn't rely upon them. So I think there's a difference between the economic analysis of whether or not something is a good policy and the legal justification. The question is, isn't that right?
So you're saying the law sometimes can be wrong? Sure. I mean, I would agree with you on that.
What I'm really saying is I think the objection that Andy and others have made to the 99% co-benefits is a legal argument, not an economic.
So I'll agree that there can be important distinctions between legal arguments and economic arguments. I think I concur with Cary that on his interpretation of when there are those differences. I will note that this isn't on the economic side. It's not just that economists typically think this. It's the agencies think this. So whether you look at EPA's own guidelines say count the co-benefits. You have OMB's guidance to all the regulatory agencies. Circular 84 says, which is the guidance for how to do regulatory impact analysis, count the co-benefits. You even have OMB in this administration in their most recent report to Congress on the benefits and costs of regulations, talking about the MAT standard, saying that the large benefits disproportionately come from fine particulates and are appropriately counted in that analysis. Now, again, these are all the economists talking about how we do the economic analysis, and there's a question at the end of the day, and this is something that's come up a number of times in legal cases, on the Clean Air Act of when we should be looking at and accounting for benefits and costs and making a determination. It goes back to, at risk of being an economist trying to quote law, was it American Trucking? Yeah. That was the case on the NACs on should you think about benefits and costs. So that is a great example of why we sometimes make decisions that are not reflecting the benefits and the cost. But from a conceptual standpoint, if our objective is, as set forth by Congress, is try to improve the air quality, we kind of want to be looking at all the different ways we can improve the air quality.
Okay, a couple of questions from the back row. So one question is for Cary and Dan. And your efforts to kind of analyze retrospectively how EPA is done in the courts sounds really, really interesting. I was wondering, are you going to build into it an analysis of different doctrinal grounds? So, for example, are you going to try to maybe you could potentially categorize the legal issues, standing, statutory interpretation, and see, how's EPA done better or worse under these various categories, or to what extent are challenges falling in with their certain categories? I think that could also be quite interesting. So that's just a suggestion. And then my other question is for Joe Aldy. So in talking about what some of the existing retrospective analyses of the trading programs, like Reclaim in particular, the effects of them, you mentioned sort of the environmental justice concerns and what the retrospective analysis suggests of those. So this is kind of a plea for actually more work by economists looking retrospectively at the distribution of pollution and of benefits more generally, or reductions in benefits more generally, of trading programs, because this is a huge argument that environmental justice groups make, and that maybe the benefits are not fairly distributed, the benefits of pollution reductions are not fairly distributed, and you see this argument being made about California's cap and trade program. In New York City, right now, the city is thinking about establishing a trading program to reduce emissions from buildings. And environmental justice groups have also raised this argument that, well, we're concerned that the benefits of a trading program wouldn't be fairly distributed. So it's a huge issue, and I would really just encourage a more retrospective analysis of it, and also more analysis of the extent to which trading programs have tried preemptively to address these EJ concerns and how various measures have fared. So now, another question.
So I can tell you all don't need another project, but we're giving you lots of ideas. So one is, how about one of you all calling the administration's bluff and going to Cary's point, do a symmetric analysis where you say, all right, if you're going to exclude, I got cut off, maybe I was protesting or something. If you're going to exclude co-benefits, let's do something where we exclude co-costs, and let's do a CBA based on that, and let's take a look at that. Either do it as to a specific rule, or do it across the board and take a look at what the cost of environmental protection would be if we took a symmetric analysis and we excluded co-costs the way they want to exclude co-benefits. That's different from the legal question that Don was raising, but I think that might have surprising traction in policy debates if one were to say, sure, we'll do that, but we also need to do this.
So I would like to ask a question about the prospective and retrospective analysis. It's really a question about utility MACT, but I'll pretend it's not. So when all of the stuff that I've looked at and all of the commentary has been treating this rule as if it's this giant monolithic single thing that either exists or doesn't exist, and that it's one thing. And then the question has been like, should we do this or not do it? And it seems like the question should be, are we regulating in the right way? And particularly, how are we avoiding two things? One, not spending money wastefully as part of that regulation, some subset or part of it. And two, avoiding specific circumstances in specific communities where shutting down a particular plant might have way more negative consequences for the people that live and work there than elsewhere. So particularly concerning circumstances you want to avoid. So variances and things like that. And in all of these analyses, it's like utility MACT is three different control mandates, one for sulfur and acid gases, or acid gases is with sulfur as a proxy, one for mercury and one for non-mercury metals. And those are three different things, and when you impose them in all these different power plants, you get different results. So how do you identify either the fat or the particularly silly consequences? I mean, like, the mercury thing might be great, but are you analyzing the acid gas thing and whether or not you're making power plants match the performance of people who got emission credits during the Title IV program for no reason? even though that particular one isn't justified? How do you tease that out in retrospective and prospective analysis?
So let me make a couple of quick comments on that. First, there's this challenge that when we look at, say, typically the prospective analysis, that EPA may say, here's our preferred rule, and the alternative is just say no regulation baseline. Sometimes if it's at the proposal stage, they may have a couple of different options, so we may have a few alternatives to look at, but it's not a very, it's often not a very rich set of alternatives to think about different ways of implementing it. And sometimes it may be, boy, there'd be a really smarter way to do this, but we don't have the authority to do that. You typically don't see that, say, in a prospective analysis from EPA. I've seen that a couple times at other agencies. DOE once did that when they were looking at a regulation and compared it to why is this regulatory approach better than a carbon tax, which of course they had no authority to do. I think, Don. So I mean, part of it is that we don't really see that kind of analysis too much prospectively, or even for that matter retrospectively, where the retrospective analysis tends to be much less common and tends to be where we already are shining the light, which is a really nice way of describing it earlier. But I think it's one reason why I think there's a lot of value that if we were to collect these data and do some analysis, but then make that available for third parties, that's where you could start to get, you relax the constraint on resources at the agency, where I go tell a bunch of my grad students, boy, look at all these data. You've always been wanting to find data, and let's go play around and really start to do some of these additional kinds of analyses to see what really is the most cost-effective way, say, to improve air quality. And that kind of independent analysis could help feed into the next round of the regulation. Because right now, I think there's a challenge at the agency that a lot of this modeling, I mean, if you look at the MATS rule, the modeling they did was quite sophisticated, quite resource intensive. There's only so many different variations of the rule they can do. It might say something that I think is kind of peculiar about what is in the current proposal by EPA. They just took the 2011 estimates and they're replicating them again in 2019. The power sector is dramatically different today than what it was in 2011 or what we projected it to be back in 2011. We have 20% less coal-fired capacity in America now than was projected with and without the regulation. And that's not because of MATS. There's actually two really good papers that are forthcoming in economic journals really showing the role of natural gas, reduced power demand, and the investment in renewables that's responsible for the more than 90% of the retirements of coal-fired power capacity. The balance is a mix of MATS and CASPR. So those rules do have an impact. They may have an impact in some areas locally, but it's much, when we think about sort of local impacts of a plant being closed down, right now it's gas and low power demand that's doing much more of that than any of the Clean Air Act regulations.
Thank you to an excellent panel, and I think we could probably ask questions all afternoon, but we're not going to because it's lunchtime.
Yes, that was another great panel. One quick thought just in terms of the three presentations, and one way to think about their subjects is three ways of thinking about what establishes legitimacy in administrative action. On the one hand, we may think of something as welfare maximizing, that is the basis for determining that something is legitimate when engaged in by an agency. Another way of viewing it might be that the ability of the agency to follow the rules and comply with the relevant procedures such that it can withstand challenge in court is a way of determining whether the agency's action is legitimacy. And another, and Emily came at this in some respects from the opposite direction, is if we feel the process is such that citizens have the ability to engage with those who are making decisions, such that they feel that process has heard them and reflected their views, that itself is a way of thinking about legitimacy of governmental action. And if people are engaging in civil disobedience, presumably that is a sign that at least some portions of the public don't feel that process has been legitimate in that way. So anyway, very fascinating panel. Lunch is in the rotunda. There are 3 buffet lines there. You may bring your food back here, one of the overflow rooms, the student lounge upstairs, outside if you think it's warmed up enough. We will reconvene at 1:15 for our next panel. But again, thank you very much, and we'll see you in 30 minutes.